My name is Marian Honnell. I'm the manager of Fair Housing at the Illinois Department of Human Rights. On behalf of our director, Rocco Claps, let me welcome you to our webinar on the rights of people with disabilities when engaging in real estate transactions. This presentation is intended for persons with disabilities who want to learn about their fair housing rights, as well as for housing providers, including landlords and property managers, who want to learn about how not to discriminate against persons with disabilities. This information contained in this webinar is for educational and informational purposes only and is not intended to be considered legal advice. This presentation covers basic information on fair housing for people with disabilities, including what is covered under the fair housing laws, what qualifies as a disability under the law, how to tell if you may have been discriminated against, how to file a complaint, what remedies might be available if you file, and where to get help. The slides with the pop quiz questions are intended to serve as a review of what's been covered before moving on to the next topic area. We often say that fair housing is all about choice. It is about choice, but especially when it comes to disability issues, it's also about equal access. If you find an apartment you like and can afford, but there are stairs or other barriers for your wheelchair, then you don't have equal access. Similarly, if you need a service or support animal because of your disability, but the landlord says there are no exceptions to the no pet policy, then you don't have equal access to the unit. The Fair Housing Act was intended to eliminate housing discrimination and to promote residential integration. The federal and state fair housing laws prohibit discrimination against someone because of membership in a protected class when engaging in a real estate transaction. Protected class is a term used to describe a category of characteristics which cannot be targeted for discrimination. Most of the protected classes cover everyone one way or another. For example, most people identify as male or female or belong to a specific race. So we are all covered under the protected class categories of sex discrimination and race discrimination. Other protected classes cover only some people. For example, the protected class of familial status covers families with one or more children under the age of 18 living in the household. If the family has no children, then they are not covered under that protected class. Similarly, only some people have a disability that qualifies as eligible for protection under the fair housing laws. The Fair Housing Act lists 7 protected classes. Race refers to Black or African American, Asian, American Indian or Alaska Native, Native Hawaiian or other Pacific Islander, and white. Note that Hispanic or Latino is an ethnicity or ancestry. It is not considered a race. Color refers to skin color or shade. We have some cases where a person claims discrimination because someone lighter than them was treated better, even if they are of the same race. National origin refers to the place where a person or their ancestors was born. The definition of religion includes all aspects of religious observance, practice, and belief, including non-belief, so everyone is protected from religious discrimination. Sex is defined as the status of being male or female and also includes pregnancy-related allegations and cases dealing with sexual harassment. A disability can be physical or mental, and the category covers people with an actual disability, as well as someone perceived to have a disability, and someone who no longer has a disability. An example of a perception of a disability might be where you've lost weight and the landlord says he thinks you have TB or AIDS, so he doesn't renew your lease. People who had cancer and are now in remission might be considered to have a history of a disability. And the definition of familial status includes families with children under the age of 18, expectant mothers, and persons seeking custody of a minor. The Illinois Human Rights Act lists 7 additional protected classes. The age category includes only people 40 and over. Ancestry refers to someone's general ancestral background, such as Hispanic, European, or Middle Eastern. This is useful when someone is applying for rent and may be discriminated against because of a Polish accent or an Asian appearance. The landlord doesn't necessarily know what specific country the person is from, but may have denied rental because of the person's ancestors being from a specific region. Marital status is defined as the legal status of being married, single, separated, divorced, or widowed. Unfavorable military discharge covers people with a discharge from the military that is less than an honorable discharge but is not dishonorable. Military status refers to service members on active duty, as well as veterans and members of the reserves. Sexual orientation covers everyone. A person is either gay, lesbian, bisexual, or straight, heterosexual. This category also covers transgender persons, called gender-related identity, meaning people whose gender identity is not traditionally associated with the sex they were designated at birth. This category was added to the Human Rights Act in 2006. Order of protection status was added in 2010. This category protects people who have obtained an order of protection from a court relating to abuse, such as in a domestic abuse situation. The law says that people should not be discriminated against because they have obtained this court order. If a landlord says, "You have an order of protection, I don't want to get in the middle of that, I'm evicting you." So that might be an example of unlawful discrimination under this section. And it's important to note that some local jurisdictions have additional protected classes. For example, the City of Chicago protects source of income, including housing choice voucher holders. Cook County also protects source of income, but excludes housing choice voucher holders. It is prohibited to refuse to engage in any real estate transaction or impose different terms or conditions on individuals on the basis of their disability. Perception of a disability is also covered, as is someone who is recovering from a condition. That would be considered history of having a disability. Here are some examples of housing discrimination that may be encountered by someone with a disability. Refusal to rent an apartment or sell a home to someone. Refusal to rent an apartment or sell a home to someone because of their disability would be considered discrimination, whether it is the leaseholder who has the disability or someone else in the household. If someone other than the household is the person who is disabled, we might use the term association to refer to that relationship. A person may allege that they were discriminated against because of an association with a person with a disability, whether it is a spouse, parent, or child who also lives in the home. If a landlord says that the unit has already been rented when in fact it is available because a person or a member of the household has a disability or is a member of another protected class, that is an example of housing discrimination termed misrepresentation. Steering is a tactic used to discourage a buyer from living in a certain area and suggesting that they seek housing in an area more appropriate to their group or where other members of their group live. And blockbusting is a tactic to persuade owners to sell or rent by telling them that unwanted groups are moving into the neighborhood. As you can see from these examples, to have a discrimination case, a person must allege that they were harmed in a real estate transaction because of their protected class, whether it be disability or another protected class. So to have discrimination that's unlawful, you have a person who was harmed, they are a member of a protected class, and they believe that the harm occurred because of their protected class. Some additional examples of housing discrimination include making discriminatory statements about a person with a disability, which might be considered discriminatory harassment, expressing an intent to discriminate against persons with disabilities, which may be a violation of the statements or advertising provisions of the law. Intimidating a person because she reported housing discrimination might be considered retaliation, which is illegal under the fair housing laws. Another example of discrimination is not allowing an exception to the no pets policy if someone with a disability needs an animal because of their disability. This is an example of not allowing a reasonable accommodation. We'll discuss additional examples of accommodations later in the presentation. In a HUD study called Barriers at Every Step, HUD tested housing providers for disability discrimination with regard to wheelchair users and users of the TTY telephone relay system. The results indicated discrimination in 20 to 25% of the cases. All right, here's the first quiz question. A man came to view an apartment listed for rent. The landlord notices the man walks with a cane and asks the man if his injury is permanent. The man says no. After walking through the apartment, the landlord asks the man if he will be able to handle living on the third floor. What do you think? Is it okay for a landlord to ask these types of questions? No, a housing provider or landlord cannot ask general questions about a person's disability without having a business reason for doing so. That could be a violation of the HIPAA privacy rule as well as a fair housing violation. A tenant has the right to choose where he or she wants to live. Therefore, the landlord doesn't have a business reason for asking intrusive medical questions. The landlord should ask all prospective tenants the same questions, and they should be related to a person's qualifications to rent, such as income and rental history. If a person has requested an accommodation, then the housing provider might have a reason to need more information about a person's condition. Again, we'll talk more about accommodations later in the presentation. Fair housing laws cover most types of residential properties or dwellings, even properties you wouldn't normally think of as residential, including vacant lots, group homes, nursing homes, summer homes, and timeshares. Dwellings are any temporary or permanent residence to which a person intends to return. Hotels may be covered under fair housing laws in an extended stay situation and are otherwise subject to the accessibility requirements for public accommodations under the Americans with Disabilities Act. Illinois state law also covers commercial real estate transactions, except appraisals are only covered for residential property. There are some exemptions. There are some properties that are not covered under state or federal fair housing laws because of the exemption. So the Mrs. Murphy exemption provides that if an owner lives in a building with 4 or fewer units and rents out the other units, the building is exempt from coverage under federal and state fair housing laws. However, there is no exemption if a landlord makes discriminatory statements. Also, a local ordinance may still cover the building. Cook County and the City of Chicago, for example, do not have a Mrs. Murphy exemption, so all housing is covered. And there's never an exemption for race discrimination. Now, the other 3 exemptions provide an exemption under only 1 or 2 protected classes. Nonprofit religious organizations that administer residential housing, such as nursing homes or retirement communities, may give a preference to persons of their same religion. For example, the Lutheran Church may run a nursing home or retirement center. In that case, they can give preference to Lutherans if they want to. Some affordable housing may legally be set aside for persons with specific types of disabilities, so that would be an exemption. And buildings reserved for seniors are allowed to discriminate based on age and familial status. They are allowed to keep families with children out of the building as long as they're following rules for senior buildings. All right, here's another quiz question. A woman owns an apartment building with 3 units in a suburb of Chicago. She lives in the bottom floor and rents out the 2 upper floors. She doesn't want to rent to families with children and ran an ad for her second floor unit that included the words, "No kids or pets." Is this legal? No. Property owners who are exempt from state and federal fair housing laws still have to follow the law when it comes to advertising. No discriminatory ads or statements are allowed. And if her property is in Cook County, it's still covered under the Cook County Housing Ordinance, which has no exemption for small owner-occupied buildings. The fair housing laws are very broad and cover nearly everyone involved in a real estate transaction. In a rental situation, and that would include the owner who owns the property. In a sales situation, the law covers the real estate agent, appraiser, insurance company, and mortgage lender. In new construction development, the law covers the architect, builder, and salespersons. Insurance companies who discriminate in providing homeowners or renters insurance are also covered. And municipalities are covered if their zoning laws or ordinances discriminate based on a protected class. And newspapers that run discriminatory ads are liable. However, courts have found that internet sites that act strictly as bulletin boards where ads are posted by others, such as Craigslist, are not liable for discriminatory ads posted on the sites. The actual persons posting such ads would be liable under the fair housing laws. There are different definitions of disability under the state and federal fair housing laws, but in general, disability refers to a serious medical condition or functional impairment that is not short-term. Under federal fair housing law, a medical condition is covered under the protected class of disability if it is an impairment that substantially limits a major life activity. Major life activities include walking, talking, seeing, hearing, learning, working, or caring for yourself. The state's definition of disability includes a serious condition that can be diagnosed that a person was either born with or may be a result of injury, disease, or functional disorder. Under both state and federal fair housing laws, physical disabilities would include, for example, limited vision, hearing, or mobility, or infectious diseases such as HIV or AIDS. Mental disabilities would include emotional or mental illness such as specific learning disabilities, panic disorder, PTSD, depression, etc., as long as it's a serious medical condition and not short-term. Temporary disabilities are evaluated on a case-by-case basis. Now, there are some exceptions. Current users of illegal controlled substances or those convicted for illegal manufacture or distribution of controlled substances, and also sex offenders and juvenile offenders are not considered disabled by the FHA by virtue of that status. Another way to be covered is if you have a condition that is in remission. This could be considered having a record of such an impairment. And as we mentioned before, a perception of having a condition still offers protection under the law. Both privately owned and publicly assisted housing, regardless of whether they are rental or for sale units, must include features of accessible design if it's a new building. So the Federal Fair Housing Act requires that new multifamily apartment buildings of 4 or more units built for first occupancy after March 13, 1991, must comply with these requirements. And this would include, for example, single-family homes, apartments, condos, dorms, assisted living developments, timeshare properties, and homeless shelters when used as a residence. So these requirements do not apply to multi-story townhomes that do not have elevators or to single-family detached houses. So what we ordinarily think of as single-family homes, unless they're attached in a multi-family building, would not be covered by these requirements. The U.S. Department of Housing and Urban Development, or HUD, published the Fair Housing Accessibility Guidelines in 1991 in order to provide a safe harbor for compliance with these requirements. Although these guidelines are not the only method of complying with the Act, they are the most commonly known and utilized by the industry. So these requirements include an accessible entrance on an accessible route, accessible public and common use areas, usable doors, an accessible route into and through the unit, accessible light switches, electrical outlets, thermostats, and environmental controls, reinforced walls in bathrooms, and usable kitchens and bathrooms. However, for properties that were built before 1991, there's no requirement to retrofit to provide these accessible guidelines. Individuals with a disability have the right to request reasonable accommodations and reasonable modifications. The rationale for this is that in order to level the playing field for people with disabilities, some barriers to their housing enjoyment may need to be removed. So let's focus on reasonable accommodations first. Reasonable accommodations are changes in rules, policies, practices, or services that allow people with disabilities the equal opportunity to use and enjoy their home. In order to have a valid request, the person must have a disability, and because of their disability, need a change to the rule or policy or practice. A housing provider may ask for documentation of the need for the accommodation if it is not obvious. The Department of Human Rights sees a number of cases involving parking. For example, a landlord may have a first-come, first-served parking lot with no reserved parking, but a person with a mobility impairment may need the space closest to their door reserved for them. If a person with a disability makes that request, the landlord may have to put up a sign with the tenant's name on it to reserve that spot for them. Or a person who uses a wheelchair may need wide, accessible space reserved for his exclusive use. In that case, again, the landlord may be required to put up a sign reserving the space for that person. A person who can't climb stairs may need a different arrangement to pay rent if the rental office is up some stairs. Maybe it can be mailed in, or the property manager could pick it up. Whatever they can work out, but it has to be recognized that the person can't go upstairs, so they need a different way to access that procedure. And another example is a person who gets a disability check on the 5th of the month might request that they be allowed to pay rent on the 5th instead of the 1st. The key to a reasonable accommodation is first that a person has a disability, and second that the request for the rule change is related to the disability, and third that it is reasonable. All right, the last example there is allowing a support animal where there is a no pet policy. So let's talk about that. We have many cases involving service animals. With a no pet policy, a person who needs a service or support animal because of their disability would request an exception to the landlord's no pet policy. The housing provider may not require certification or training for the animal, or ask people to give details about their specific medical condition. It should be enough for the person to provide a letter from a doctor or other professional establishing the need for the service or support animal. Nor can the tenant be charged a pet deposit or a pet fee. But a housing provider may charge for actual damages caused by the animal and can also impose specific safety or health requirements, such as a requirement that the animal has had its shots. But a housing provider cannot impose weight limitations or breed limitations or require a person to get an extra insurance policy to cover the animal. All right, reasonable modifications are actual physical changes to the unit or common areas that allow people with disabilities an equal opportunity to use and enjoy their home. Some examples are removing doors so that a scooter could fit through the doorway, changing a sink to allow wheelchair access, adding an exterior ramp, again for wheelchair access, adding grab bars or a roll-in shower in a bathroom, or installing a stair railing in a common area. Now let's talk about who pays for modifications. In the case of reasonable modifications, the tenant or person making the request must pay for a structural change unless it is federally subsidized housing, or the person can find an agency that will pay for the ramp or other large expense. A property owner may impose requirements for the work, for example, that it be performed by someone with experience, and that the ramp or other structural modification be removed when the tenant leaves. The landlord can require the tenant to pay into an escrow account to be sure that there is money to have the ramp removed, and that it be removed in a safe manner at the end of the tenancy. And the landlord should not require that changes to common areas be removed. Changes to common areas such as ramps, hand railings, etc., are to be maintained by the condo association or property management company and covered under the regular insurance of the facility. They should not require a condo owner, for example, to obtain a special insurance policy to apply only to the ramp that they paid to install. So how does one determine if a specific request is reasonable? So the courts have determined that requests are not reasonable if they impose an undue financial burden, impose an administrative burden, fundamentally alter the nature of the operations, or put others in the community in danger. So what constitutes an undue financial burden depends on the property and would be determined on a case-by-case basis. An example of fundamental alteration to the business is where a person asks that the on-site property manager administer his medication on a daily basis. Such a request clearly falls outside the normal services provided by the on-site manager. An example of putting the community in danger might be a service dog that bit one of the tenants. So that tenant is most likely going to have to get a different dog or perhaps have the dog muzzled whenever it's outside of the unit. So it's important to note that even if a housing provider believes that denies a request and because he or she thinks it is unreasonable, the law requires the housing provider to engage in an interactive process to determine if an alternative solution can be found that would be reasonable. So the essential elements of a reasonable accommodation are that the request must be made either verbally or in writing. The request must be essential for the use or enjoyment of a dwelling. The request must be practical and feasible. And the tenant must obtain the landlord's approval before the tenant moves forward with the modification or accommodation. So landlords do have a right to ask the tenant to provide verification that the accommodation or modification is necessary for the individual to have full enjoyment of the premises, if the disability is not obvious. Generally, this proof can be provided by a letter from a treating professional and verification that the request is necessary for the tenant to fully enjoy the premises. All right, here's another quiz. As a result of a disability, a tenant who lives in a 4-unit building is physically unable to open the dumpster for trash collection. The tenant has requested that the landlord send a maintenance staff person to his apartment on a daily basis to collect his trash and take it to the dumpster. Is this a reasonable accommodations request? So the answer is maybe. It depends. Remember, a reasonable accommodation is reasonable, and it may depend on the size of the building as to whether such a request would be reasonable or not. In this case, because the building is a small operation, it may be limited in financial resources and maintenance staff. If it is an undue financial and/or administrative burden for the housing provider to grant the requested daily trash pickup service, this requested accommodation may not be reasonable. However, the landlord should engage in the interactive process and work with the tenant on an alternate solution, perhaps placing a smaller trash bin in a more accessible area that the tenant can access, and that the maintenance staff could later transfer to the larger bin at their convenience. So reporting discrimination is the first step to stopping it from occurring in your community, and many acts of discrimination can only be investigated if someone reports them. It's also important to note that a person is protected against intimidation or harassment for reporting housing discrimination. A person who believes that their fair housing rights have been violated can file a complaint in several ways. A complaint can be filed with the federal government, which is HUD, the U.S. Department of Housing and Urban Development, or the state agency, in this case, the Illinois Department of Human Rights. HUD has a new app for iPhones that makes it very easy to file. Just go to the App Store and search on discrimination. A fair housing organization or disability rights organization can also provide assistance in filing a charge, and a person can also file a case directly in federal or circuit court. Pattern and practice cases involving systemic discrimination can be filed with the U.S. Department of Justice or the Illinois Attorney General's office. In order to file a complaint or charge of discrimination with the Illinois Department of Human Rights, a person can start the process by calling IDHR and describing the situation. Our housing inquiry phone number is 312-814-6229, and this number is answered by a bilingual staff person, bilingual in English and Spanish. We can also be contacted via email at idhr.fairhousing@illinois.gov, or a prospective complainant can complete our intake form online. After reviewing the information, we draft a charge if appropriate and send it to the complainant for signature. At the same time, we send the charge to the person or organization being charged with the act of discrimination, called the respondent. Once the respondent receives the signed charge, they have a duty to provide a written response. An investigator assigned to the case will ask both parties to consider a voluntary resolution to the matter. If the charge cannot be resolved or settled, the investigator requests information from all parties and will interview the complainant, the respondent, and any witness, and sometimes makes a visit to the property. IDHR then makes a recommended finding and sends a report detailing interviews conducted and documents obtained, and explaining how our determination was made. Besides interviewing the complainant and respondent and witnesses, the investigator collects documents and uses other evidence to determine whether there is substantial evidence of discrimination. To obtain testing evidence, a fair housing or disability organization typically sends out testers with similar profiles and housing needs, but with different protected class statuses, such as race or disability, to the same available housing unit to see if the two people are treated differently because of their protected class status. Without testing, housing discrimination may not be detected. Now, it's important to note that the department cannot assess the credibility of anyone's testimony. In simple terms, this means that if the complainant and respondent have conflicting stories about what happened, the investigator doesn't decide who is telling the truth. But it doesn't mean that one party automatically wins if the parties disagree as to what happened. Most times, there is other evidence in the case, so the decision does not rest on whether one or another of the parties is telling the truth or has believable evidence. However, if the resolution of the case requires believing the evidence of one party over another party, the department will make a finding of substantial evidence and refer the matter to the Illinois Human Rights Commission so that a judge may make that determination at a public hearing. A person can file a charge within 1 year after the alleged discriminatory practice occurs or ceases. In cases of ongoing, continuing discrimination, a complaint can be filed within 1 year after the practice ceases. A case can be filed up to 2 years after it occurs or ceases in state or federal court. And any time that the case was open at an administrative agency such as IDHR or HUD, is told, meaning it is not included in calculating the 2-year filing period. If a judge finds that discrimination did occur, various types of damages can be awarded. Make whole damages compensate the person for the damages caused by the discriminatory acts, such as actual or out-of-pocket expenses. These might include compensation for travel and time off work seeking other apartments, storage fees if incurred, and higher rent or travel expenses because of renting at another location. Compensatory damages can also include damages for emotional distress if those can be proved. And the category of affirmative or injunctive relief can include a lot of different things. For example, the judge could impose reporting requirements where the apartment has to keep a record of everyone who applies for rental and who is allowed in. It could also include monitoring for compliance, units set aside for a certain group, free rent, and required fair housing training, or advertising in media targeted to the protected class that was involved in the case, and whatever else would undo the damage caused by the discrimination. In federal court, punitive damages can be awarded. At the state level, a judge can award civil penalties for up to $10,000 for the first offense, $25,000 for the second, and $50,000 for the third. And attorney's fees and costs can be a substantial portion of the damages. Congratulations! You have taken steps to stop housing discrimination by learning about the fair housing laws. Hopefully this presentation has given a basic understanding of the fair housing rights of persons with disabilities. However, a general overview can't address every specific situation. For questions about how the fair housing laws apply to a specific case, you may wish to consult an attorney. If you suspect you may have been discriminated against, feel free to contact our office either by email, phone, or in writing, and we will let you know if your situation is something we can investigate. If you are interested in learning more about fair housing, you may wish to review the Department of Human Rights' other webinars on other fair housing topics. For more information, see the resources handout associated with this webinar.